The 20th, 2018. It's 10 a.m. and it's my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Mrs. Bohannon, would you please call the roll?
Dennis Bridges.
Here.
Mark Cochran.
Here.
Robert Davis.
Here.
Jeff Duffer. Clark McKinney.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Mr. President, we have 6 of the 7 board members present.
Thank you, Mrs. Bohannon. Next item on the agenda is approval of today's agenda.
So move. Second.
I have a motion by Mr. McKinney, a second by Mr. Davis. All in favor?
Aye.
We'll move to the legal report this morning. Ms. Gino?
Good morning. I will be presenting the first part of the legal report, and then Pam Spicer will be presenting the last part of the legal report today. Our first item is complaint number 2018-012-151. This is an establishment with no disciplinary history. The complainant alleges the respondent lacked professionalism, attention to details, and staff on the day of the deceased's memorial service. Specifically, the complainant alleges, 1, the chapel was not set up or physically ready for a 1 p.m. visitation. 2, the respondent was low-staffed on the day of the service. 3, the service did not start on time. 4, the start of the service was rushed and disorganized. 5, the staff was not at the doors to pass out programs as people came in. And 6, over half of the guests did not receive a program. In response to these allegations, the respondent indicated, 1, neither the respondent's notes nor the funeral bill reflected a 1 p.m. visitation in the chapel was agreed to. 2, the memorial service began at 2 p.m. as scheduled. 3, by 12:45 p.m., the family had 30 to 40 people standing in the visitation room waiting for the memorial service to begin at 2 p.m. The staff attempted to accommodate the crowd and continually added more chairs as best they could. 4, door greeters were temporarily pulled to accommodate the family with more chairs. 5, failure to provide programs to all family members may have been due to a short supply of programs printed, which the family created and printed themselves. And 6, the programs were passed out as the family processed in. In response to these indications, the complainant insists a 1 p.m. visitation was discussed at the initial meeting with the respondent and that the only items missing from the contract at that time were keepsakes. Because of this, her sister came in to sign the contract to include keepsakes at a later date. The respondent, however, claims it was not until this second meeting that the family indicated it would also like a 1-hour visitation prior to the service. An investigation into this matter was conducted. As part of the investigation, the complainant's sister provided the contract from the initial meeting and the contract she signed. Neither contract reflected a 1 p.m. visitation. Under facility fees, the original contract, not signed, reflected only use of facilities and staff for memorial service. The second contract, signed by the complainant's sister, reflected use of facilities and staff for memorial service and use of overflow for memorial service. Ultimately, the respondent did provide a visitation service but did not charge the family for it. According to the respondent's manager, when the complainant's sister came to sign the contract, she advised the establishment had received numerous calls about the services and suggested the number of attendees may be larger than anticipated. At that time, the complainant's sister agreed and requested the use of the larger main chapel for the memorial service to accommodate everyone. However, because the respondent had not charged the family the basic service fee, the owner explained the best he could do would be to block out the smaller chapel and allow the use of an overflow room prior to the memorial service. The manager advised she adjusted the funeral contract and the family agreed to pay for the use of the overflow room. The complainant's sister disputes this, claiming she believed the chapel and visitation room had been reserved in the initial conference. Recommendation, close.
Motion to approve.
Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran. All in favor?
Aye.
Opposed? All right, next.
The next 3 items, items 2, 3, and 4, have been summarized together. The first complaint is number 2018-015-381, an establishment. The second is 2018-015-401, a funeral director. And the third is 2018-015-451, an expired apprentice funeral director. All three have some disciplinary history. In the complaint, the complainant alleged unlicensed activity and the ejection/ban of family members from both visitation and funeral services for the deceased. Family members were relatives of the deceased and former employees of the establishment. The family learned of the ban when one of the former employees was asked to leave the visitation after having been at the visitation for approximately 1 hour, and was further advised to tell the other former employee that she could not come to the visitation or funeral. Respondent denied the unlicensed activity and indicated that the former employees were aware they were not allowed on the property. An investigation was conducted, which does not support a finding of unlicensed activity. The circumstances related to the removal of the former employee from the visitation and the ban of them both date back to 2013. The respondent funeral director/owner failed to provide any reason for the alleged ban despite ample opportunity to do so. However, both former employees appear to allege that in 2013 they were suspended for 30 days for insubordination, at least one with pay, after which they refused to return and instead went to work for a competitor's establishment. The investigation did not reveal a substantive basis for the alleged ban of these two former employees, nor was there sufficient evidence to support that such a ban was ever in place. Both former employees deny ever being told that they were banned from the property. One had been an employee of the respondent's establishment for 5 years and the other for 33 years. According to the expired apprentice funeral director, on the night of the visitation, the respondent funeral director/owner was monitoring the visitation on security cameras at the funeral establishment from her residence. He stated she called him to advise that she had seen the family member in attendance from the video. After this call, he requested to speak with the family member in a private room where he asked her to leave. He claimed she became irate and combative and told him that she would not leave unless the police removed her. He called the police, but the family member left before they arrived. 2 policemen did arrive at the establishment during the visitation. It appears the expired apprentice funeral director was acting solely upon the orders of the respondent funeral director/owner. The deceased's son stated that had he known some of his family members would not be welcome at the visitation or service, he would have selected a different funeral home. At the time of the former employee being asked to leave the premises, evidence supports that the individual had been there for at least an hour and was sitting with a small child and visiting with other family members at the time she was asked to leave. At that time, she was told to advise the other former employee that she was not welcome on the property for the visitation/funeral. Neither former employee attended the funeral of the deceased the next day due to the conduct of the respondent funeral director/owner and the desire not to cause a scene at the services. Recommendation: establishment, authorization for a formal hearing, authorization of a civil penalty in amount of $2,000. Funeral director, authorization for a formal hearing, authorization of a civil penalty in an amount of $2,000. Expired apprentice funeral director, close.
Questions from the board?
Was there any type of restraining order in place, or was this just a verbal, you're not welcome here, for the employees?
The respondent claims that the employees were told that they were not allowed back on the property, but both of the former employees told the investigator that they were not told that they could not come back on the property. And the respondent didn't provide any documents showing that they had told these people that they weren't allowed on the property.
Thank you. I'll make a motion to approve.
I have a motion by Mr. McKinney. Is there a second?
Second.
Second by Mr. Shackelford. All in favor?
Aye.
Opposed? Next.
Items 5 and 6 on the report have been summarized together. The first is 2018-02-1681, which is an establishment. The second is 2018-02-1821, unlicensed embalmer. Neither have a disciplinary history. On April 3rd, 2018, an employee of the establishment submitted a complaint alleging the unlicensed embalmer embalmed over 200 bodies from 2017 through March of 2018, despite not being licensed to do so. The employee also alleged the existence of a logbook with embalmer signatures. He claimed the log provided the name of the established manager, but the signatures did not belong to her. In support of his complaint, the employee identified 5 witnesses, all former or current employees. An investigation was conducted and the following was found. 1. Witness number 1 denied knowledge of the allegations. 2. Witness number 2 denied knowledge of the allegations. 3. Witness number 3 initially indicated he was aware of a complaint being filed, but he had no direct knowledge of the allegations. He then indicated he was under the impression that the unlicensed embalmer stopped working for the establishment 2 weeks prior, but that she did embalm bodies prior to her leaving, and that the establishment's owner and managing funeral director signed off on the embalmer signature book for her. However, witness number 3 ultimately signed an affidavit denying knowledge of the allegations. Witness number 4 denied knowledge of the allegations. 5. Witness number 5 denied knowledge of the allegations. 6. The employee/complainant denied making the complaint and stated that he had only seen the unlicensed embalmer perform as an attendant, makeup artist, and hairstylist. He attested to this in a signed affidavit. 7. The establishment's managing funeral director advised that the unlicensed embalmer assisted in the embalming room receiving cases, preparing the table, instruments and table for the embalmer, maintaining sterile conditions, transferring cases received to the crematory for refrigeration/cremation, dressing and cascading cases, applying cosmetic, and styling hair. 8. The unlicensed embalmer initially denied the allegations, but then stated upon her initial employment with the establishment, she did assist and embalm a few trauma cases during her first 30 days of employment. 9. The establishment's owner initially indicated that during the 30-day waiting period on the unlicensed embalmer's application for a reciprocal license, as she is licensed in another state, she did perform embalming procedures, but after it was learned she could not get licensed in Tennessee, she did not perform anymore. In his sworn statement, however, he denied the allegations of the complaint. 10. The establishment's owner provided a copy of the referenced embalming book. He indicated it was kept for the purpose of logging bodies transported to the establishment. He also indicated there was no book kept for logging in who conducted an embalming. He indicated that record is kept on death certificates only. The logbook entries were categorized into the following sections: deceased's name, date of death, place of death, date/time received at funeral home, removal by, personal effects, and embalmer's initials/date. Recommendation: establishment, letter of warning, unlicensed embalmer, letter of warning.
Questions or comments?
Motion to accept.
Second.
I have a motion to accept by Mr. Cochran, a second by Mr. McKinney. All in favor?
Aye.
Opposed?
The next item is item number 7, 2018-024141. This is an establishment with some disciplinary history. Complainant alleges that on September 27, 2017, respondent contacted it for services needed on 1 hearse and 4 limousines. Complainant alleges it and respondent agreed respondent would pay $1,600 upon completion of services. Complainant alleges that despite it completing services in October 2017, respondent has yet to pay complainant for those services. Respondent failed to submit a response to these allegations. Recommendation, authorization for a formal hearing, authorization of a civil penalty in an amount of $500 plus $250 for failure to respond.
Motion to approve.
Second.
I have a motion by Mr. McKinney, a second by Mr. Bridges. All in favor?
Aye.
Opposed?
The next item is item number 8, 2018-027581. This is an establishment with some disciplinary history. The complainant's father passed away on April 26, 2018, after which the hospital called the wrong funeral home. Due to the family not knowing about a change of ownership, the complainant alleges that when he told the respondent his father was in the wrong place, the respondent asked for $875 for embalming and removal, $650 for embalming, $225 for removal. The complainant then claims the respondent lied about the fee because it did not embalm his father. Complainant indicates the $225 removal fee was paid. In response to these allegations, the respondent indicates it spoke with the deceased's wife, the next of kin, after the deceased passed, at which time she gave verbal permission for respondent to embalm the body. However, the embalming was ultimately not performed as the complainant, not next of kin, demanded the deceased be removed immediately to another establishment. The respondent indicates that while it did ask for $875 for embalming and removal, that was because it believed it was going to be embalming the remains. Once notification was given for immediate removal, however, no fee for embalming was charged, only the $225 removal fee, which was paid by the receiving funeral establishment. Recommendation, close.
Motion to approve.
I have a motion by Mr. McKinney, a second by Mr. Davis. All in favor?
Aye.
Opposed?
The next item is complaint number 2018-01195, which is an establishment with some disciplinary history. A routine examination was performed on December 14, 2017. During that examination, it was discovered that copies of 2 funeral directors' licenses were not available for inspection. In response to this finding, respondent's owner indicates that he had obtained the required copies and filed them in the crematory office after July 11, 2017. He further indicates that had he been present for the examination, he could have verified the licenses were in the office. He, however, admitted that it was an oversight on his part that the funeral director present during the examination was not aware that the other licenses had been put on file. Recommendation, letter of warning.
Motion to accept.
Second.
I have a motion by Mr. Cochran, a second by Mr. Bridges. All in favor?
Aye.
Opposed?
The next item is complaint number 2017-068-621, which is an establishment with some disciplinary history. Complainants allege that they entered into pre-need funeral agreements in November 2009 with the former owner of the funeral establishment. The two paid a total of $9,150 via money order for 2 separate contracts and received documentations that an irrevocable trust account would be established pursuant to the contract. The former owner of the establishment signed both contracts and endorsed the money order. Complainants have since received a phone call from the new owner of the establishment. He advised that the money they gave the former owner of the establishment was never placed in trust and the funerals were not prepaid. Recommendation, close. The complaint has been opened against the former owner.
Motion to accept.
I have a motion by Mr. Cochran. Is there a second?
Second.
Second by Mr. McKinney. All in favor?
Aye.
Opposed?
Items 11, 12, and 13 are represents. The first is complaint number 2018017 for establishment. The second is complaint number 2018017 471. Funeral director number 1. And the third is complaint number 2017491. Funeral director number 2, who is not the managing funeral director. The establishment has some disciplinary history, but neither of the funeral directors do. These matters were previously presented to the board at its May 8, 2018 meeting. The board decided to table the matters until its next meeting. Complainant alleges respondents refused to pay for the merchandise and services his establishment rendered before the deceased's family switched establishments. Specifically, complainant claims the deceased family incurred $3,095 before the change, which includes embalming $800, autopsy $400, transfer of remains $400, and basic services $1,495. In support of his claim, complainant supplied a contract signed by the deceased's father, not next of kin. The contract depicted a balance due of $2,350. A $745 discount was given. In response, respondent funeral director number 1 indicates respondent establishment offered to pay complainant $1,600, but complainant refused payment. The $1,600 represents a payment for charges for embalming, autopsy, and transfer of remains. Respondents dispute basic services were provided. Respondent funeral director number 1 requested complainant provide respondents with a copy of the contract and the complainant's general price list, but complainant refused to provide the price list unless respondent funeral director number 1 requested a copy in person. An investigation was conducted, which revealed a genuine good faith dispute as to what is owed. There was also a question as to whether the individual who contracted with complainant had the authority to do so on behalf of the deceased. Respondent funeral director number 2, who is not the managing funeral director, was not personally involved with the deceased family and indicated he had no firsthand knowledge of the event. He had no firsthand knowledge of the events surrounding the complaint. Respondent funeral director number 1 corroborated this, indicating respondent funeral director 2 was never directly involved with the deceased's family. Recommendation: establishment, close. Funeral director number 1, close. Funeral director number 2, close.
Due to the complicated circumstances of this matter, I'm going to make a motion to approve.
Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran. All in favor?
Aye.
Opposed? Next.
Ms. Spicer will finish out the rest of the legal report.
All right.
Good morning, everyone.
Good morning.
First, I want to call your attention to numbers 14 through 19. These are going to be presented together. Number 14, 2018-001501 establishment. Number 15, 2018-001541 funeral director, who's the managing funeral director at this time. Number 16, 2018-001571 funeral director number 2. Number 17, 2018-001601 embalmer. Number 18, 2018-001641 expired apprentice funeral director. And number 19, 2018-001661 expired apprentice embalmer. You see the disciplinary history. Everyone except the expired apprentice funeral director and expired apprentice embalmer all have history. I'll move to the summary. These complaints stem from a complaint received regarding unlicensed activity of the funeral director whose license is currently suspended. The complaints were opened against the establishment, current funeral director who is the establishment manager, and the suspended director and embalmer, and the expired apprentice. The matter was sent out for investigation, and the investigator has not been able to confirm any unlicensed activity by the suspended funeral director from the individuals who would need to have firsthand knowledge, which would be required to go forward in litigation in this matter. The complainant has no firsthand knowledge of any unlicensed activity. The investigator spoke to several individuals in the area with whom the complainant stated would have firsthand knowledge, but those witnesses did not possess firsthand knowledge of any unlicensed activity. Based on the fact that the department has no firsthand knowledge, we would recommend closure of these complaints.
Motion to accept.
Second.
I have a motion by Mr. Cochran, a second by Mr. Shackelford. All in favor?
Aye.
Opposed?
Thank you. I'll move to 20 through 23. These matters are marked for discussion. Number 20, 2018 011871 establishment. 2018 011941 funeral director number 1, who's the managing funeral director. Number 22, 2018 011831 funeral director number 2. And number 23, 2018 011861 the embalmer. You see the disciplinary history, particular attention to funeral director number 2 and embalmer, who are currently summarily suspended by this board since July 2017. The summary consists of: these complaints are pursuant to a notice of violation issued to the above respondents due to the respondents allowing and promoting a photograph of the suspended funeral director and embalmer to appear on the Facebook page owned by the funeral home. An additional investigation incurred into the Facebook page, which shows the suspended funeral director presiding over a funeral and graveside procession in violation of the suspension order. Other violations that were noted in the notice of violation include that the general price list was incorrect when compared to the immediate burial price range, casket price list, and basic services fee disclosure was incomplete as requested or required, by the FTC. Also, a casket was offered for sale on the immediate burial list but not available on the casket price list. We are recommending authorization for formal hearing for revocation against respondent number 22 and 23. That respondent is currently suspended. I want to remove or ask the board for consideration to remove settlement by consent order. Because these matters are currently pending in litigation, I see no reason to offer a settlement, as I do not believe a settlement would occur. And then we need to discuss any recommendation for the funeral establishment and the current funeral director, who is the current establishment manager. As we discuss these, I want to remind the board that we need to preserve the anonymity of the complaints. If we don't do that, we risk a motion being filed to have this matter heard by an administrative law judge alone. I also want to ask the board to consider certain factors. When you are making a determination to suspend, revoke, or issue a civil penalty, you are authorized to issue a civil penalty of between $250 and $1,000 for each violation. However, the rules of the funeral board state that when you are going to assess a civil penalty, you need to consider the following factors: whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation and the risk of harm to the public, the economic benefit gained by the violator as a result of noncompliance, whether the violator has been guilty of similar violations in the past, and whether there's been any discipline imposed, the interest to the public, and the length of time that has elapsed between the alleged violation and the filing of the complaint. That last factor, I do want to note that when we are talking about the Facebook post, just so the board is aware, the license was suspended in July 2017. Between July and the time of the notice of violation, which occurred in December 2017, there are approximately 22 separate Facebook posts depicting an image which would be considered in violation of the order. However, at the time of the notice of violation, the respondent remedied the situation and removed the image. So the image is no longer there. So that is something to consider if the board is considering a civil penalty. As I stated, you are making two decisions, one against the funeral establishment itself, and the owner of the funeral establishment is summarily suspended, and a second determination against the current funeral director, who's the establishment manager.
Ms. Spicer, the Facebook postings, were they just pictures or were they videos or?
There are two separate incidents to consider. The notice of violation stems from images, pictures. That is the 22 times that there was a picture. It's the same picture. That was removed when the notice of violation came out. There is a separate incident that occurred later, not stemming from the notice of violation, that is two videos. The same deceased, but there is two videos, one of the funeral and one of the graveside procession.
Have they also been removed? Or are they still up?
You can find them if you need to.
Would a member of the public be able to see those again, or have they been completely removed?
The two videos have not been removed. Now, that doesn't mean I haven't checked as of today, but obviously when we received this notice of violation, those videos existed. And to give you maybe a little more detail on the two videos, it depicts the individual directing the pallbearers where to sit at the funeral, and then at the graveside procession, directing the pallbearers. So the issue is for the current manager, that respondent is failing in the respondent's duty to oversee the funeral home and allowing the respondent who is suspended to give the appearance that that respondent is presiding over funerals and or graveside services. And then, of course, we have the issue of the establishment itself, which is owned by the respondent who is suspended. Just in case you all have questions as far as the pending litigation that we currently have, it was previously set and continued due to these pending complaints. I have an outstanding email to opposing counsel asking to set this matter in October, but as you all are aware, we either have to agree to set it or I have to file a motion and get the court to get the administrative law judge to give us a hearing date.
The current manager who is licensed, was he asked if he or she, were they there where those videos were taken?
That I don't know.
Okay.
Of course, we can only see what's in the video. So I would only be making an assumption whether they were there for the entire funeral and entire graveside service.
Excuse me, do we know if who's administering the site? Is it the local funeral home or was it a third party?
What was the question?
Do we know who was managing the uploading, the administration of the site of Facebook? Was it the funeral home manager or was it a third party company?
For purposes of the fact that we have pending litigation, our position is the funeral home manages the website or the Facebook page.
So, Mr. President, do we need, how many motions do we need to deal with this? Is it, Ms.
I personally, and Ms. Spicer can give us direction, I personally think it would need to be two separate matters,
or three?
or three.
Did I hear you correctly say that you wanted to delete the authorized settlement by consent order? Is that correct?
Correct. Given the fact that there is pending litigation on respondent number 22 and 23, and that respondent has counsel, I do not believe it would be necessary to offer a settlement in this matter since there's litigation pending. If the board adopts the recommendation for revocation against respondent number 22 and 23, we would need to move that matter directly into litigation, and I would either need to amend my notice of hearing and charges that is currently pending or file a new notice of hearing and charges and hopefully have those matters all set before the board and the administrative law judge together. That's why I need to remove the recommendation on further thought, and after speaking to opposing counsel, I do not believe any settlement of this matter is going to be possible.
But you want to, if we make a motion authorizing the formal hearing for revocation against the respondent 22 and 23, you're hoping that this would be included and would be settled at the same time as whatever else is hanging out there?
Correct. And I do believe that it would be best to have one motion to approve the recommendation, if that's what you all are so inclined to do, on number 22 and 23, and then a separate motion required for the other respondents once you all reach a determination on your recommendation on those.
I'll make a motion that we authorize a formal hearing for revocation against the respondent number 22 and 23.
I have a motion by Mr. McKinney. Is there a second? Mrs. Spicer, following Robert's Rules of Order, am I allowed to second that?
I would defer to the board attorney for that.
I would actually need to review the rules. I'm sorry.
I'll second the motion for the purpose of opening the floor for additional discussion.
I have a motion by Mr. McKinney, a second by Mr. Shackelford. Further discussion.
I feel like this is in order. I don't feel like that council would have asked for this harsh of a penalty if they did not feel like that these allegations were, if they were not serious enough, they wouldn't have asked for this. And plus, whatever else is pending out there, if we have done a summary suspension, those allegations also are pretty serious. So that's why I moved to accept the council's recommendation.
Or other than the Facebook posts, are there any other evidences or indications where these two individuals appear to be practicing as licensed individuals, either in advertising or?
I would have to say not at this time. But given the fact we are in litigation on the other matters involving the same respondent, I will let you all know the facts in this matter are constantly ever changing, and I receive new information frequently, which would obviously result in a new complaint, but I just wanted you all to know that based on Mr. McKinney's comments. That's why, of course, these complaints are pending. And it, again, kind of goes to what Mr. McKinney was saying. We have a notice of violation that is just the depiction of an image. Then, based on the notice of violation, we then found videos, which were separate from the notice of violation. My opinion is this respondent continues to portray, act, and hold himself out as a funeral director. When we get to litigation and the proof comes out, obviously facts are ever changing, and he or she will have their day in court to explain themselves. But when someone is summarily suspended by this board, and then is holding themselves out to the public at a funeral attended by many, graveside procession attended by many, appearing to be acting as the funeral director when the license is summary suspended, that gives rise to a complaint, and that gives rise to, I think, a necessity of something more than a civil penalty because the individual is already summary suspended, which is why I recommended revocation for this individual.
Do we know if there was a licensed director present during this particular incident as well?
That's what we don't know, as Mr. Bridges was asking me. The current funeral director, the establishment manager, I do not know specifically whether that person was present during the time this occurred on the video.
Or any other licensees that might be employed by that firm.
Correct. I think the issue is the video, which will be shown at a hearing, does not depict this respondent simply attending the funeral. It is clear from the video he's not in attendance.
In other words, his licenses have been suspended, summarily suspended, and as far as the general public can see, nothing has changed. He's probably doing business as usual. Would that, or at least given the impression that it's business as usual?
Correct. And he can obviously have his own position, but if you have your photograph front and center on your Facebook page after you've been summarily suspended, that gives the impression that you're still acting as the funeral director. That in and of itself, to me, is enough. But then we have the additional component of the videos.
I'm going to play devil's advocate for just a second. So, as the only unlicensed member on the board, could I preside over a funeral, direct pallbearers, and do the general service as long as one of these gentlemen were present? That's just a general question to anyone who can. I mean, is that allowed? Could I preside over a funeral?
My position is no, based on the reading of the statute.
That would be my response as well.
Okay.
Work,
One of
yes.
the
Preside,
issues
no.
is how do you define presiding over the service?
Right, I agree
Is
with
the
that.
handling of pallbearers presiding over a service, or is that a role that an unlicensed assistant can fulfill if a licensed director is present and presiding, if you will, over the service?
That would be my question also.
Right.
I agree with you.
The unlicensed person can't be in charge, so to speak.
And to call your attention to the statute, and within the definitions, it's 62.5-101. It specifically states, as Mr. McKinney was stating, that funeral directing means the practice of directing or supervising funerals, and or the practice of preparing the dead human bodies, and it goes on. But I think that directing pallbearers where to sit clearly gives the impression that you are supervising a funeral. I do not think you have to preside over the entire funeral to give the impression that you are supervising over part of the funeral.
Well, one thing, you know, if a licensee's license is suspended, they automatically ought to know they've got to be very careful as to how they portray themselves. I'm assuming that whoever this is a smart individual and knows that, you know, your license being suspended is a serious matter, and that, you know, until that's resolved, you know, you need to be very careful about what you do. And it just seems to me like that the suspension is being ignored.
So I guess the big question in my mind, and I think Mr. Shackelford was alluding to it as well, is I'd like to know for sure, was a licensed person there? That's the only part that I struggle with, I guess. And I don't know, do we ask that question before the formal hearing and allow them a response? Or that's the big question in my mind is was a licensed individual there?
All of that information would come out during the hearing. Is that not correct?
Correct. But let me also call your attention to 62.5.314. That discusses specifically the use of names of unregistered persons, which is restricted. It specifically states that the name of any living person who has not been licensed, as provided in this chapter, should not be shown or displayed upon any funeral establishment or used alone in or as part of connection, association, combination, or together with any name or title of any person, firm, corporation. Basically, by that, it is stating that you cannot allow an individual who is not licensed to give the appearance or display their likeness as the funeral director. And that has nothing to do with the videos. That has to do with just the Facebook images themselves, which, yes, have now been taken down. But as Mr. McKinney was stating, it's the whole issue of this individual was suspended in July 2017 and did not remove their likeness as an image on Facebook until they received the notice of violation in December. Then the secondary issue, Mr. Cochran, which you are discussing, is the 2 videos. There would likely be no way to know until the hearing what the respondent's position would be on who else was present. I will say it does appear that someone else was present. But that begs the question, why didn't that person preside over the entire funeral? Why wasn't that person directing the pallbearers where to sit?
So when we summarily suspend someone's license, what instructions do we, you know what I'm saying, what, are we specific? Do we say, hey, don't go close to the funeral home, don't be at a funeral, don't, you know what I mean? What is it understood that they can and cannot do?
No, we do not. I will say this, ignorance of the law is no excuse. You are a licensed funeral director. You've been summarily suspended by this board. You also have an attorney that represented you at the summary suspension. You should know what you can and can't do. If you're summarily suspended, nothing prevents you from owning that funeral home, but you should not do anything that portrays that you are acting as a funeral director or embalmer. But no, we do not. I cannot give legal advice to another individual. Especially that individual is represented by counsel. They receive an order that their license has been summarily suspended, but we do not go into, because imagine if we did.
Sure.
We can't go into every single scenario that they can or can't do.
And I guess maybe that's maybe more so of my question is, what does the law say they can and can't do? So we heard the part about the using their name, and obviously they can't provide embalming services so I guess I want to make sure that we are right on the specifics of the law and not just the spirit of the law. I want to know what the law specifically says and were they in violation of that specifically.
My position is when someone's license is summarily suspended and they're acting as a funeral, if they're a funeral director and embalmer and their license is suspended, they can no longer do any act that is funeral directing or embalming. It is up to, which may lead to where we are now. It is up to the respondent to decide what they can and can't do. We are not telling them what they can and can't do because we're saying you can't act as a funeral director and embalmer. Anything within the statute, which you would have to go through the entire statute to know what you can and can't do, but the definition is clear of what a funeral director is. So if that person reads that definition or has counsel explain it to them, it's up to them. Of course, that's why we have litigation. It's ultimately up to the trier of fact to determine whether or not that individual was acting as a funeral director or not. So what I'm saying today is based on the facts that I have. The department's position is this individual has continued to portray himself or act as a funeral director and or embalmer. The license is already suspended. Of course, the board can take the position that you're not going to take the recommendation of revocation, but then I guess it begs the question of what would you do?
So if we voted to accept the recommendation, is the license immediately revoked, or we're just authorizing the hearing for revocation?
Correct. This is not, as the board did on the summary suspension, this is not that case. This will require a filing of a notice of hearing and charges or an amendment of the current notice of hearing and charges to include these new allegations. And then the only thing that happens is the license remains suspended until we have a hearing on all of these matters. As it relates to respondent number 22 and 23, that's all we're talking about right now. That's the same individual. So we would have a hearing. The license is already suspended. We would have a hearing, the proof would come out, and at that time, a decision would be made as to what would be done. The recommendation is revocation so that I can go forward with a notice of hearing and charges and include that language in the notice of hearing and charges. When we get to the hearing, we'll all have to see how the proof comes out.
I think
I agree.
I think in summary, based on the statute, this individual with a suspension was not to be doing anything that John Q. Public could say he was participating or directing a funeral, and that has not been the case.
Also, this third party, this licensed funeral director that's at the establishment now, was he hired by one of these, the owner?
I would assume so. I'm going to make an assumption on that because we don't have, I don't think, any direct proof. But since the respondent that's summarily suspended owns the funeral home, one would assume that the current establishment manager was hired by that individual. And that's, of course, a separate recommendation. Number 20 and 21 are separate recommendations. I'm by no means stating that the board needs to recommend revocation as to that individual. But we do need to address what we're going to do. I do think that as it relates to number 22 and 23, based on the discussion, we need to have possibly another motion to approve the recommendation or modify the recommendation, and then include the language that we would not proceed by settlement, because if the recommendation remains revocation, we just need to move to litigation and not worry about going through the settlement procedure.
So,
Kenny, are you willing to?
so do you need the motion amended to include the language not to settle by consent order?
Correct. To remove that language from the recommendation is all
Okay.
we would need to say. And based on the discussion, a renewal of the motion, including removing that language and then whatever the recommendation of the board is, to accept my recommendation or to change it on number 22 and 23.
And then after that, then we're going to talk about 20 and 21.
Correct.
Okay.
I will amend the motion to reflect what Ms. Spicer has asked for, that we authorize a formal hearing for revocation against the respondent number 22 and 23, and that this not be settled by consent order. Does that work?
Second, I consent to the amended motion.
We have an amended and a second. Any further discussion? All in favor?
Aye.
Any opposed? All right. We'll move to the second part.
So now on number 20 and 21, number 20 is the establishment itself, which is owned by the respondent that's suspended. Number 21 is the current acting managing funeral director. I will not recite the factors that we went over when you consider a civil penalty, but we do need to make some decision about how we are going to handle the funeral establishment itself, and then the acting funeral director, which also goes back to the question of whether this particular individual was present during the funerals, which will probably not come out until the hearing.
One thing
My
about-
position would be she that individual was present, but we're relying on a Facebook video, so the respondent may have a
But whether
differing
he or she
opinion.
was present or not, they still allowed the individual to do what was done.
Correct.
And the only thing about that is if, of course, the individual that's been suspended, if that person is the owner and that person hired the manager, it's probably likely that he's dictating to that managing funeral director, what to do, and I'm going to do this, and so I don't know that person would have a whole lot of control as to their actions in these specific charges.
Well, it would be surmised that they would just be manager in name only.
Right. Yeah. So, my personal feelings, I don't know that we would want to do a penalty against the manager, but one against the funeral home establishment would definitely be in order.
And again, the penalty ranges from $250 to $1,000 per incident for each violation of the statute. And I would defer to the board on that, depending on what you all see as appropriate against the establishment. You also, just so you have, as you all know, you have the ability to suspend or revoke or issue a civil penalty. And that's why I wanted to mark this for discussion, because I knew that we would have some discussion about the revocation of the respondent in 22 and 23.
If we did a civil penalty against the establishment and authorize a hearing, would that be handled completely separate from the others, or could that be lumped in to all this other also if they did not agree to pay the penalty?
Given the fact that the respondent has an attorney, I would have to discuss that and see whether or not there would be an agreement to have these heard together, or whether that would be a separate hearing. My opinion is it would be best to have these all heard together, but opposing counsel could object to that, and those would be handled separately.
Mr. McKinney, I understand where you're going with that, but I also feel like that the manager, even though he or she may just be following direction from the owner, I feel like it's their responsibility as well to step up and do what's right. So
Or quit.
Or quit, yeah. So I personally think that we need to consider something against the manager as well, not just the establishment. What that is, that's certainly up for discussion.
And again, if I can call your attention to the statute 625317 for grounds of denial, suspension, revocation of a license. Of course, as you all are aware, you can refuse to may suspend, revoke, or refuse to renew an establishment license based on misrepresentation or fraud, false or misleading advertisement, or aiding and abetting an unlicensed person to practice within the funeral profession. Those are three particular factors that stand out within 317.
Did you have any recommendation in mind for these last two, or were you just going to completely leave that up to the board?
As it relates to the current manager, my opinion is this person is under the direction and control of the owner. I do not believe revocation is appropriate. I do believe a penalty and even possible suspension may be appropriate. I'm not talking about a summarily suspending because we're past that point. I'm talking about at the time of a hearing. So I would ask the board, as it relates to the manager, to consider a penalty and possibly a suspension, especially if the proof does come out, for instance, that that individual was present and allowed the respondent that's suspended to participate in the funerals that are depicted in the videos. Today, you're authorizing whatever you choose to authorize. Nothing is happening today. So again, what we're doing is you're authorizing me to go forward with a notice of hearing and charges with civil penalties and or a suspension. Particularly as it relates to the manager, this would include an authorization of settlement. So, for instance, if you authorized an amount of a civil penalty and a suspension for a period of time, I would send out a consent order to see if I could get this resolved by settlement. I do not believe that's going to be possible, but I would like that option. If that individual does not settle, then we would be going to litigation. As it relates to the establishment, I will defer to the board, but the establishment is owned by an individual that you've authorized his license to be revoked. So that is something for the board to consider.
Do you know, or are you able to tell us, is this manager or was this manager already on the payroll at the time of the suspension, or was this a new hire to be manager during the suspension period?
My understanding is this person was hired after the suspension, but I will defer to Mr. Gribble in case he has other knowledge about when this individual was hired. But I do not believe this individual was working at the establishment prior to the suspension. Is that correct, Mr. Gribble?
At the time of the suspension, this individual, to my knowledge, was not working there. However, this individual has been associated with this firm in the past, is my recollection. So there is familiarity with the establishment, between the establishment and the current manager, but it's my understanding that the current manager was not an employee of that establishment at the time. Well, let me say it like this. At least the current manager was associated with this establishment or another associated establishment that the suspended funeral director has ownership in. As far as appointing a manager, there's a form that every establishment fills out where basically someone representing the ownership appoints a manager, and the manager assumes responsibility for managing the establishment. It's a form that we've used probably for 2 years now. So we have a signature from someone representing the ownership of the funeral home and a signature from the manager that's being appointed accepting the responsibility to manage that establishment.
Just for discussion, board members, the funeral, the owner of the establishment's license has been revoked.
Suspended.
Suspended, excuse me. More than likely, this type of scenario is going to continue. More than likely. I honestly don't see it stopping. I think the only way we'll make any headway is to have some type of strict consequence for the establishment, myself.
And this person's licenses were summarily suspended, which my understanding is more of an emergency action. This wasn't just a suspension that was left out there dangling for a couple of months. I mean, we took emergency action to suspend the license, and for whatever reason, and could be a lot of reasons, the hearing has been delayed, which I don't personally like. I think it ought to be done more timely, but I know the legal process on both sides, makes a determination on, when the hearing is set. So, but I agree. I mean, it just seems like that the suspension didn't mean very much. That it's just been business as usual, and if this hearing is not set until October, if this board doesn't make some type of impact, it'll be business as usual until the hearing. And then we don't have a guarantee that the hearing will be in October. I mean, it could be put off again to whenever. That's something we don't have any control over.
And to speak to the continuance and the fact that it has been pending as long as it has, part of the reason that it was continued is because of these new complaints. We have received, of course, we have the ones you all are looking at, the 4, and then we have had other complaints that were investigated and resolved that were closed. But the problem is, when I'm in litigation against a respondent and I continue to receive complaints, I need to look at those complaints, because those complaints are going to have an effect on the pending litigation, which is what caused the initial continuance. And then since that time, opposing counsel and I have had some difficulty agreeing on a new date. He also issued discovery, which has been responded to. You have 30 days to respond to discovery, so things do get delayed when you get into litigation, but then you receive additional complaints, then you receive discovery that you have to answer, and you have an investigation pending. There's no way to set a hearing when there's an investigation pending on new complaints that may have an impact on my litigation. That's why we're hoping for October. But as Mr. McKinney was saying, I'm not going to guarantee it's going to be October. I think that this needs to be resolved, I agree, in a timely manner. But, opposing counsel is not necessarily pushing this for whatever reason.
Yeah, I understand. And, of course, the timeliness is not only, it's... of course, they may not be pushing for it, but I mean, as soon as this needs to be resolved as soon as we possibly can, just to be fair to him and the public that's
Correct.
Left out there dangling, not knowing what's going on with this firm or this individual. Would I guess maybe, does everybody think that maybe the easiest one of the two left is to do a penalty against the manager and then deal with the establishment?
Correct. We probably should handle these in separate motions, one at a time.
President, I make a motion, excuse me, that we authorize a formal hearing against the establishment and seek a civil penalty of $1,000 per occurrence with the establishment.
I have a motion by Mr. Shackelford on the establishment. Is there a second?
Second that.
I have a second by Mr. Bridges. All in favor?
Aye.
Opposed? All right, now for the establishment.
That was the
I
establishment.
mean, I'm sorry,
correct?
for the.
You meant that is the
individual.
establishment or the manager? The establishment, okay.
Yeah, now for the other.
Manager. I will make a motion for a civil penalty of $1,000 and an authorization for a hearing.
$1,000 per occurrence or $1,000?
I'm going to say just 1,000 on that manager.
I have a motion by Mr. McKinney. Is there a second? Motion dies for lack of a second. Open again for discussion.
Call for motion that civil penalty of $500 against the manager.
$500 total.
Yes.
Are they automatically authorized for a formal hearing, I guess, with any civil penalty? Or
Right. The authorization for these two respondents would be to authorize a formal hearing with settlement by consent order with the current motion of a $500 civil penalty. If the respondent chooses not to settle by consent order, it would then proceed to a hearing with a $500 penalty.
All right, we have a motion by Mr. Davis. Is there a second? There is a second by Mr. Shackelford. All in favor?
Aye.
Aye.
Any opposed?
No.
Opposition by Mr. Bridges.
I believe that covers it, but just to recap, on the establishment manager, the board has authorized a formal hearing with recommendation for settlement with a $500 civil penalty, correct? As it relates to the establishment manager.
That is correct.
As it relates to the establishment, you've authorized a formal hearing with $1,000 per occurrence, which could possibly be settled by consent order. If so, that would be great. If not, we would proceed to formal hearing, correct?
That is correct.
On per occurrence of Facebook images, we probably have to, per occurrence.
That was my understanding.
So we have the Facebook images, which consist of a picture or the two videos.
And then plus, you think about how many days those were up.
Correct.
I don't know that you want to do, if it was up 20 days, I don't know if you want to do $20,000. But, I mean, that's, it could be violation per day.
That was how I was looking at it.
Okay.
So the issue with that, just so the board is aware, for purposes of settlement, we would need a dollar amount. For purposes of hearing, you are correct. It's per occurrence to be determined at the hearing. But if you are authorizing me to move forward with settlement negotiations by consent order for the establishment, we have to set a more specific dollar amount. For instance, are you authorizing me to settle if the establishment is willing to pay a $20,000 penalty, or is it a $5,000 penalty? You are correct in your language on the per occurrence when we get to a hearing. Or you can stand by your recommendation and no settlement. You're authorizing formal hearing with a $1,000 per occurrence penalty. Proceed directly to the hearing.
President, that was my intent, was for that to be determined at the hearing.
Thank you. And that was the motion. I just wanted to make sure you all were clear. That would not be for settlement. The motion was formal hearing, $1,000 per occurrence. There will not be any a consent order generated against the establishment.
That's correct. Yeah.
That's fine with me.
Thank you for your time.
I know what that vote's already taken, but I was wondering if it's not inappropriate, what Mr. Bridges' thinking was. Were you thinking that it should have been harsher or less harsh, or?
I believe when we first spoke to us, you said there were 17 occurrences?
22 images.
Okay.
On Facebook. It's the same image. If you're familiar with Facebook, of course you have an image saved, and it appears every time there's a post on Facebook, the same image. So when I'm referring to 22 images, it's 22 posts about funerals that are occurring, and that person's image, the respondent number 22 and 23's image, is the image that's on Facebook. That was on Facebook, sorry.
And my opposition was if the individual is the manager of the firm and maybe he's a manager in title only, but if he's responsible, he's responsible. And I feel like if the establishment was responsible per occurrence, that the manager should be responsible for per occurrence. Maybe not the same amount per occurrence, but that's my thinking.
I understand. I appreciate everybody's input.
Thank you, and thank you for the discussion.
Thank you, Ms. Bison. Next item is Director's Report. Mr. Gribble.
Mr. President, the first thing is a legislative update for this meeting. A notify regarding statute changes from the 2018 legislative session will be sent to those that have interested parties around July the 1st of this year, those that have registered with the Board of Funeral Directors and Embalmers as desiring to receive such communications. This notification will include any public chapter from 2018 that affects the licensees or the registrants of the board. And this is the process for an interested individual to sign up for the notifications. If they'll visit our website, funeral.tn.gov, hold the cursor over the Contact Us, click on Get Notified, enter their name, email address, and zip code, and then check which programs they want the notifiers to come from, which generally I would suggest they check the Board of Funeral Directors and Embalmers and check Burial Services, and then scroll to the end of the page and click on Sign Up. And I did that for the benefit of those that might be watching on live stream or watching the video later. And then additionally, topics are available for programs, and you may click on a particular program to review the archive notifications for that program. So it's a good way to go back and see what laws were passed in, say, 2016, 2017 that affected the board, and it's a good way for people to know what's going on and what to expect. It's to be proactive to give them some education about what law changes happened. The licensee report, these are the report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of May 9, 2018 through June 19, 2018. You have 2 establishments and a multitude of individuals who received either funeral director and/or embalmer license. We have no closed establishments to report to you since the last board meeting. Disciplinary action. This is a report of consent orders that have been administratively accepted or approved by the Executive Director pursuant to the Board authority and as reported on the April and May 2018 Regulatory Board's disciplinary action reports. So you have a list of the establishments and/or individuals, their location, their violation, and what the penalty was. As far as the complaint report, Ms. Bohannon tells me as of yesterday, we had a total of 66 complaints. 36 of those were for funeral director and/or embalmers, and 30 of them were for establishments. And Mr. President, I'll be glad to answer any questions the the board has, but that concludes my report if the board doesn't have any questions.
Any questions for Mr. Gribble?
Motion to accept the director's report.
Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran. All in favor?
Aye.
Opposed? Next item is the board meeting dates for 2019.
President, you have a list before you there. These are meeting dates that are set for the second Tuesday of each month. As most board members are aware, typically the board sets 12 meeting dates, one for each month, on the second Tuesday. And then normally, depending on the legal report and what business might be coming before the board, usually there are 3 or 4 of those canceled at various times through the year because it's not necessary to meet and to have the expense of meeting. But these need to be set so that legal will have dates that they can engage in ALJ if they need to, and that's why they're set so far in advance.
Motion. So move.
Second.
I have a motion by Mr. McKinney, a second by Mr. Davis to approve the meeting dates. All in favor?
Aye.
The approval of license applications.
President, you have no individuals nor any establishments to come before you today.
New business, rulemaking update.
Hi, I just wanted to update you all on the funeral rules. They have been reviewed internally, and there were very minor changes, so I do not need to represent those to you all. I sent those to the Office of the Attorney General earlier this month for a pre-review for constitutionality. Once I hear back from them, those rules will then be sent for the Governor's Office for pre-review as well. If approved, and if there are no major changes to bring back to you all at that point, I will go ahead and schedule a rulemaking hearing, and that requires a substantial amount of notice. So it wouldn't be the month following the Governor's Office's approval. It would be probably 2 months following that approval, just because the amount of notice that I'm required to provide the public for the rulemaking hearing. And so that is the rulemaking update. Any questions?
No question. Just want to thank you for a great job on that.
Thank you.
Any legislative proposals from the board?
Mr. President, this time slips up real quick. It was actually, if we had our meeting this time on their second Tuesday, as we normally do, we would have had a few days to, if the board wanted to submit some type of proposal. But actually, the time is coming past for us to be able to submit any kind of proposal for consideration from the board. As all of you are aware, this is the end of this administration's time, and the criteria for submitting proposals for the coming year was mainly is if there was some kind of law in conflict of a federal statute or something like that. So the criteria was very, very narrow, and historically this board's not proposed any legislation unless there was some major happening in the industry or such as continuing education. I want to make you aware of it as well, that normally we have an opportunity to do that, but this time the time is just passed for us to be able to submit anything.
Right. Anything else need to come before this board? If not, I'll entertain a motion to adjourn.
Ooh,
Second.
beat you to it.